Speaker. As with all debates on law and order, Mr. Speaker, the rhetoric is the easy part. It's easy to stand up and say that we're going to be tough on crime by locking up more criminals for longer, that we're going to make the community safer by locking up more people for longer. The reality is somewhat different. And I find it totally offensive to suggest that based on their support or opposition to this particular measure, any member of the House would label another member of the House or another group of members of the House soft on crime or tough on crime. In fact, it's a lot more complicated than that, and the public of New Zealand deserve better than the type of hollow rhetoric that so often characterises the debates that we have on law and order. People aren't stupid. People are smart enough to know that we have one of the highest incarceration rates in the developed world, and doing more of the same is simply leading to more of the same. For the last couple of decades, we have been on a trajectory that has seen us exponentially increase the number of people that we have put into prison. And has that made our communities safer? No, it has not. It has not made our communities safer, and it will not make our communities safer. I absolutely abhor violent crime. And I think, yes, those who commit violent crime should be held to account for their actions. Absolutely think they should be held to account for their actions. But I think we as an entire community should also be held to account for the moves that we take to prevent the crime happening in the first place, and to actually get serious about addressing the drivers of crime. And I want to congratulate Simon Power for having the gumption to actually hold a ministerial meeting on the drivers of crime and actually get serious about some discussion around those things, because we can't keep turning our backs as a society on the people who commit crimes, suggesting that it is only them that is responsible. There's the old saying, it takes a village to raise a child. Absolutely true. And we can't simply turn our backs on the ones that get into trouble. We have to all accept responsibility for them. We have to accept the fact that in many cases, offenders have themselves been victims before they were offenders. They have often lived in households where there was little love shown towards them, where in fact they have been abused, where the love that they have known in their household has actually been violence. We can't turn our backs on them and simply say that we're going to lock them up and throw away the key. We have to look seriously at the causes of criminal offending, including the causes of violent crime. The rhetoric, Mr. Speaker, is the easy part. The solutions are a lot harder. And I, for one, am not going to label members on any side of the House as soft or tough on crime based on their whether they support or oppose this bill. I want to talk about a number of serious concerns that I have with this bill as it stands, and suggest, Mr. Speaker, that there are other better ways that we can deal with the issue. I believe that this bill removes some of the motivation from offenders to reform themselves, to better themselves, and increases in some cases the likelihood of reoffending and the seriousness of the reoffending should it occur. We can keep people in prison for longer. There is no evidence that suggests that makes them less likely to reoffend from anywhere. This bill is bad for victims, and the Ministry of Justice has advised that this bill will lead to fewer guilty pleas and more appeals, which means the victims of crimes being dragged through lengthy and painful trials and appeals processes. Mr. Speaker, that is one of the key questions that we should always ask in a law and order debate on any issue. What will this bill, what will this measure do for victims? Will it make them better off? Will it help them? Will it simply provide an outlet for their anger? And I can understand why victims of crime often have so much anger towards those who commit criminal offending. That's one of the reasons why the victims of crimes aren't on juries and aren't the judge, because they can't make objective judgments on that. It's why we have an independent judiciary. It goes back hundreds of years, and it's absolutely the right thing for us to do, to have an independent judiciary, so that a jury even, so that proper decisions can be made free from the emotion of being directly involved in something. I understand the anger. that so many victims have, that doesn't mean that we should necessarily be locking people up for longer and resorting to a much more sort of primal instinct of retribution. It's not the right way to go. Mr. Speaker, there are many other problems with this bill as it is drafted. It removes judicial discretion. As I said, we have to trust judges. Only on the first qualifying offence will the court solely determine the sentence. For the second offence, the offender will serve any prison sentence that is imposed in full without parole. And for the third offence, the judge will have no discretion whatsoever. They will be required to impose the maximum sentence for that offence with no parole, regardless of any extenuating circumstances. What, I ask then, is the point of having an independent judiciary if the judges don't get to make independent judgments? The judges, we have to trust them. We have to give them discretion. We also have to question what this bill will do in terms of the discretion that it provides to the police and the pressures that it may place on the police. For example, this bill removes all judicial discretion at the third strike, severely limits it at strike 2, but the police, on the other hand, will have a much greater deal of discretion. Under this legislation, the police could, for example, lay a charge of aggravated assault, of assault of aggravated injury against an offender, which is a 3 strikes offence, but they could then plea bargain with the offender and reduce the charge to aggravated assault, which is not eligible. They could do that on the condition that the offender pleaded guilty to the lesser charge. So the police gain more discretion to prevent something actually getting into a court of law than the judges do, than the discretion the judges have once the matter actually reaches the courts. How can that be fair? How can that be consistent with an open and transparent and fair judicial system? It simply cannot be. This bill potentially leads to punishments not fitting the crime, because under this bill it is no longer just about the most serious offenders, as the government claims, because some of the qualifying offences can cover conduct ranging from serious to relatively minor. This bill could lead to situations where the punishment does not fit the crime. It potentially reduces the incentives or the ability to gain guilty pleas from those who have committed an offence. Studies in the United States have found that the rate of guilty pleas decreased after the third strikes law came into force because there was no incentive to plead guilty, and defendants hoped that a jury would find them not guilty when it discovered what the penalty would be. That's the other challenge on the judicial system and on those who serve in a jury. Will they find somebody guilty if they know that the consequence of doing so is that that person may well never ever be released from jail? So we put more pressure on the judiciary. It places more pressure on victims of domestic violence because they may be less likely to report abuse if it was more likely to result in a lengthy prison term for the abuser. And that's something that we should think very long and hard about. And of course, it places tremendous pressure on those who work in the prisons. Because if a prisoner is never going to be released, where is the incentive for them to behave appropriately in prison and to make any effort whatsoever to reform their ways? If they know that they are in prison, if they know that they're going to go to prison if they get caught, it creates more of an incentive for them to go further. If you're on the third strike and you've done something and you think that you could do another crime, maybe kill the person who saw you do it in order to not be caught, and you know you're going to prison anyway, what's the incentive and the offender knows they're going to prison anyway, what's the incentive not to do that? There is none. That rhetoric in this is easy. The complexities are so much more difficult, Mr. Speaker. We need to actually step back from the raw emotion of the law and order debate and consider what will work. We need to step back and consider the drivers of crime. We need to look at drug dependency. We need to look at victimisation within the home, within family violence and so on. Those are the things we should be looking at. This is a punitive bill and it will not make our communities safer.
Call Melissa Lee.